Let's delve into the origins of DAKA and explore the history of DAKA. First introduced in Congress in 2001, the Development, Relief, and Education for Alien Minors, commonly known as the DREAM Act, would have granted those brought to the United States when they were aged 16 or younger, thereafter known as Dreamers, eventual citizenship. Responding to Congress's repeated failure to pass the DREAM Act or any other significant legislation aimed at modernizing immigration policy in response to the presence of millions of undocumented immigrants in the United States, President Obama acted unilaterally. At his direction, on June 15, 2012, Secretary of Homeland Security Janet Napolitano issued a memorandum that outlined the administration's Deferred Action for Childhood Arrivals, or DACA, policy. DACA, a U.S. federal government policy established in 2012 through executive action by President Barack Obama, allowed young unauthorized immigrants who were brought into the United States as children and did not have citizenship or legal residency to remain in the country with temporary lawful status. In 2012, over 780,000 youth received protections of the DACA program by the Department of Homeland Security. This bill was passed by the Democrats under President Obama. Today, June 17th, President Biden signed into law DACA protection for some 500,000 undocumented so-called dreamers. President Joe Biden on Tuesday announced two new election year executive actions that could provide relief to thousands of undocumented immigrants who have been in the country for several years. Today's a good day, Biden said, to cheers from an audience at the White House. The first action aims to streamline the process through which undocumented spouses and undocumented children of U.S. citizens apply for lawful permanent residence. The policy will allow non-citizen spouses married to U.S. citizens to apply to live and work in the United States legally without having to leave the country. Non-citizen children of applicants would also be eligible for protection. To be eligible for the program, non-citizen spouses must have been in the U.S. for at least 10 years as of June 17, 2024, without having been previously legally admitted into the country or paroled into the country. They also must have been legally married to a U.S. citizen as of the same date and must also be deemed not to pose a threat to public safety or national security. If found eligible, the spouses would be given 3 years to apply for legal permanent residence. The Department of Homeland Security estimates that up to 500,000 spouses could be eligible for the program, and approximately 50,000 children of these spouses would also be protected. Thanks for watching. I hope this video answered more of your questions. So please subscribe to our channel for information like this. See you in the next one.